Hi friends, in this video I am going to give you a legal dictation from Annamalai University's book, and the title is Law of Property with Easement, page number 230. Title is Misrepresentation, and speed is 100 words per minute. Let's start guys. Last 5 seconds, 4 seconds, 3, 2, 1, 0. Start. The prior mortgagee will lose his priority in favor of the subsequent mortgage if there is a misrepresentation on the part of the prior mortgagee which induced the subsequent mortgage to advance money on the already mortgaged property as though it were unencumbered. In Raman Chetty versus Steel Brothers 21 MLJ 936 PC, the facts were the prior mortgagee had concurred in inducing a second mortgagee to advance money as a first charge on the security of the already mortgaged property, and also concurred with a second mortgage being executed with the recital that the property was unencumbered. It was held that under the circumstances there was a clear case of not only misrepresentation but also of fraud, and the first mortgagee could not turn round and claim priority. Even an innocent misrepresentation would be sufficient to postpone the prior mortgage. There is a difference in the meaning of what is gross negligence between English and Indian law. English law, gross negligence meant not only negligence but negligence amounting to fraud. So priority was lost when gross negligence was accompanied by fraud and not otherwise. Lord Eldon in Evans versus Bicknell held mere negligence is not sufficient to deprive a mortgagee of his priority. His negligence must be such as to amount to evidence of fraudulent intention, such as to lead the court to the conclusion that he is an accomplice in fraud. So mere carelessness of or want of prudence will not be a ground for postponement of a prior right. Northern Countries Insurance Company versus WIP 1884 51 LT 806. But the modern trend is on negligence pure and simple. The leading case is Oliver versus Hinton 1899 to CHD. The facts are as follows: A created an equitable mortgage in favor of B. Later he sold the property to C and conveyed the legal estate to C without notice of the mortgagee. When C asked for the title deeds, A represented that the title deeds could not be given as they related to some other properties also. C was careless in that he did not ask for inspection of the documents. On the question of priority between the right of the equitable mortgages and the purchaser of the legal estate without notice of the prior encumbrance, it was held that there was gross negligence on the part of C, and so he took his estate subject to equitable mortgage. All the decisions after Oliver's case stress not so much on fraud but on utter negligence. Indian law. Let us now study the position here in our country. The decision in Oliver's case and the judgment of Lord Selborne in Dictation versus Maccleston were followed by the Calcutta High Court in a number of cases. Lord Selborne observed Dictation's case where there is a duty upon a person to do particular act, he must be presumed to know what he ought to do. Stop.